Morning, everyone. Welcome to the March 14th meeting of the Citizen Oversight Board. I'll call the meeting into order. We have a good agenda today, I think, and we'll be meeting with the Chief of Police for the City of Denver, have some good discussions there. The board is in the final throes of developing our annual report, and I think it will be nothing if not robust because it's really long. We'll work to make that shorter in the future, but there's no shortage of details for the community to read there. So we encourage folks to read that. One thing I wanted to talk with the board on, so it's technically due March 15th, which is tomorrow, which is not a business day. And so depending on how comfortable folks feel with the current draft, we could publish today, or we could publish on Monday, and I'm happy to take, the weekend for folks to do one more review before we send it out. We will still be in compliance there, but just start the meeting by asking opinions from the board members on that.
So that's your question, is whether to publish today or tomorrow or Monday?
Today or Monday.
I would prefer Monday. That does give us a little bit more time.
Yeah. Okay. Great. That was my inclination as well. So that sounds good. We'll plan on that. Community, look for that document on Monday. And then OIM, your annual report is also due on the 15th. Are you publishing Monday as well?
I think we anticipate publishing today.
Okay, great. And having seen that report, I'm excited about all the information we'll be providing to the public in the next few days. So, okay, great. Well, let's get into our business. And if folks have had a chance to review the minutes from our Valentine's Day meeting, if you can approve those with much love, with a motion.
Abstaining since I did not attend the meeting.
Great, okay. Can I have okay, thank you. Not much love, I guess, for those minutes. Thank you. All right, all in favor, aye?
Aye.
Great. Any opposed? Great, the motion passes. Okay. Next, let's see. Reminder, we still have 2 vacancies on the board. We're looking for those to get filled. Those are both mayoral appointments, so continue to encourage folks to apply. We have a lot of work to do, so could use your help. Lastly, I think we had a number of folks from the public, and let me see if they're joined as attendees, from the public who had planned to make comments today. Daniel, are you joined by anyone in your space?
I am not the people that I was looking at. I think I did hear from Mrs. Holyoke-Face that they're going to postpone their comment until following. They were able to schedule a meeting with the OIM for next week, I believe, and so pending the outcome of that meeting and another records request they've filed, they're gonna reconnect with us later.
Okay, great. Perfect. So we'll reserve public comment till the end in the case that there is any, and we'll sort of get into it, but the chief's not here, so we can't. One thing I'll mention to the board is that there is a coalition that's beginning to form around changes to the disciplinary procedures, and there's a meeting Tuesday, and Daniel will send out the link to that, but I'm out of town, but if we could have a board member attend, I think that would be really helpful. Okay, Rufina can be available for that. That's great. I think this is going to be meaningful in terms of starting public engagement on
What time?
4:30, I think.
Okay.
I think it's a virtual meeting based on the link, but
okay, great, thanks.
Daniel will send that out as part of the Friday roundup email.
Do you mind as well?
Yeah, we'll just send it out to everybody.
Great.
And who does this coalition consist of, Julia? Do we know what groups?
So far, it's Task Force on Reimagining Policing. We're trying to loop in Together Colorado. And I think that Task Force includes a number of other organizations in its natural formation. So that'll be.
Got it.
Julia, Pastor Davis is one of the attendees here, and he just raised his hand. I assume he wants to chime in on that subject. Is that all right?
Yep, go ahead, Pastor Davis. Actually, let's wait till the end, because I want to make sure that we have enough time for a conversation with the chief, and then we can get together at the end of the meeting.
All right.
Okay, cool. Chief Thomas, thank you for joining us today. Happy Friday. We've got a lot to cover with you, and I know we sent some questions in advance, so maybe let's start there. Oh, actually, I think there was one thing that we were going to ask based on, I'm just looking at the question. Something came up midweek this week that we were going to bring, but we'll bring that up at the end. So go ahead if you wouldn't mind with our questions.
Okay, thank you. So the first question is, as it relates to the officer shooting at the gas station in Colorado on January 27th, what kinds of factors should an officer be considering when shooting at or near gas pumps? So first off, officers are taught during basic training at the academy to be sure of their target and beyond when firing their weapons. This is reinforced by range staff during biannual firearms qualifications as well. And additionally, ballistic experts have confirmed that the likelihood of an explosion or some other significant event resulting from a bullet penetrating a gas pump is near impossible, as the actual gas tank is underground and take a spark actually to ignite the gas fumes, which are the actual flammable hazard. And then the second part of that question, when K9 units are used to locate a hit suspect, are the dogs trained to bite the suspect? And what was the desired or intended outcome in this incident? And so police service dogs are used primarily to locate dangerous suspects. And depending on circumstances, assist in physically apprehending dangerous suspects. The ultimate goal of police service dog deployment is as a de-escalation tool. They alert officers to suspects' locations and then aid in apprehension if necessary. The desired outcome in this incident was just to locate the suspect. While searching perimeters, officers often move into uncleared areas without knowing where an armed suspect may be hiding. In turn, officers are in dangerous exposed positions. During this particular incident, while officers were moving into an open backyard with no cover, the police service dog located and physically apprehended an obviously dangerous suspect who was hiding in a shed. The officers allowed this allowed officers the ability to move to the suspect and take him into custody. With a layer of safety, the dog was immediately released from the bite when officers were in control of the suspect. Every one of our Metro K9 handlers are certified in maintaining control of their police dog. They make announcements before they, release the dog. So there's an announcement that the dog is going to be released and that there's a potential for the dog to bite. And then just to give some context, over the last 3 years, there's been over 1,700 K9 deployments, resulting in just 46 bites. So that's less than 3% of all K9 deployments result in a bite.
Just a couple of follow-up questions on that. So based on your data, one can assume dogs are used often and an important tool in your work. And I couldn't recall sort of hearing about a dog bite. So a couple of questions. One, if a person is harmed as a result of interactions with the police, and it's a dog, does it sort of raise the level of, is it a critical incident for that reason, or sort of like it creates a new threshold, or?
We don't consider it to be a critical incident, but we do consider it to be a use of force. And so there is a
That's what I mean, yeah.
report that is completed and it is reviewed by internal affairs to determine whether or not it was appropriate in that instance to use the dog and have the dog perform the apprehension.
And then, when officers are trained to shoot, they're mostly trained or always trained to kill with their shots, right? We're not sort of trying to slow someone down.
Yeah.
And what about, or correct me if I'm wrong, but then when we use dogs, you know, are there sort of stages of interventions with a dog, or is it sort of like release the dog is expected to sort of,
So let me just address your first point. And that is that we don't train officers to kill. What we train officers to do is to, to eliminate the threat. And so, we're trained to aim for the area that is the easiest to hit. And so that would be center mass, kind of, from the shoulders to the pelvis. And so that is the target that we train regularly on. And so that's really the intended purpose is just to neutralize the threat. And then as it relates to the service dog, so again, the handler has physical control over the dog as they are searching, and then when they locate a suspect, there are announcements that are given while that dog is still under control. There's even warnings about what the dog is likely to do when it comes across a suspect who has not complied. And then after, I believe it's 3 standard announcements, the dog is released. And then the apprehension takes place. And as soon as there is either compliance or officers are able to move in and safely secure someone, commands are given and physical effort is taken to have the dog release their bite.
usually they just bite once, or they're sort of like,
No, I think actually they bite.
Stefan's laughing at my question, but I'm sort of like, does it end up in some like, repeated interaction with the dog, or is it just like?
Yeah, well, so what it does is it bites and holds. And so if you are able to wrestle yourself from the dog's grip, it will reattach itself. And so, but it's not intended to maim or anything like that. It's really intended to, again, to grab, hold and control, and maintain that control until officers can come and take over control.
Okay, thanks. And then the last question is, so what I understand is the person ran away, they went into some random person's backyard, and then we lost sort of line of sight to them. Did you use a drone in this circumstance to try and look?
We did use a drone, and the drone, I think, was able to identify some heat signatures. And we actually identified 2 people with from those heat signatures. The one was not the suspect. We did a show up. It was clarified that was not the suspect, and the second person we verified was the suspect.
Okay. And then in that case, they run into some random person's backyard. That person is not a suspect or engaged in the activity, but like say you went back there and that person had like a full grow operation or, some other illegal activity in their backyard. And how does that work in terms of sort of next steps?
I mean, I'm not the legal expert, but my supposition is that because we had a legal right to be where we were, anything that we were to observe from that legal vantage point would be admissible.
Okay, thanks.
And I think what we would do, like, let's say, for instance, given a similar fact scenario, we were to enter into a backyard, searching for a suspect and see, something, we would then apply for a search warrant, which would then allow us to return, continue that search and make that recovery.
Okay. And then in the case that, you start the drone a couple blocks away and you fly over someone's backyard and you happen to notice other things while you're flying, what happens there?
Well, my understanding is that it doesn't, I'm not, I think our initial discussions about drone operations is that it doesn't focus until it gets to its destination. Now, I suppose if we are using the drone to, to scan several backyards because we're not sure which backyard he's in, and then the backyard that he's not in also, happened to have an illegal grow that we were able to see. Then again, I think what our course of action would be to apply for a search warrant, and a judge may tell us that we didn't have legal authority to see what we saw and deny that search warrant.
Okay. My child up and says, forget what you know. And so that might be a case where you have to do that. Okay. Okay, thank you. All right, go on to the next question unless other board members have questions on that.
So I think we're at number 2, which is what is the status of your efforts to create a pool of community members to serve as on the use of force review board. And we continue to solicit interest from community members to serve on the use of force board. There are currently 3 community volunteers, up from 2. We're in the process of working with the Office of the Independent Monitor to interview a 4th. 2 others were determined to be unsuitable. So we do continue to engage, RNOs and district community advisory boards to look for more. We're not satisfied with those 3, and so we will continue to go through a process to identify further community volunteers.
Rufina, I see your hands up.
Morning, Chief. How are you?
Ethan, how are you?
Good, good. I wanted to ask, what is the criteria for unsuitability and who has determined that criteria?
Yeah, so our Internal Affairs Bureau and our Public Review Office are the one who are, the kind of the
I'm having a hard time hearing you, sir.
Yeah, I think your speaker is fading.
Is this better?
Oh, much better.
Okay,
Yes,
sorry.
thank you.
So anyway, the people that are reviewing those files are our Conduct Review Office and our Internal Affairs Bureau. And those are the primary components of our use of force board. And so, if we identify someone that has a criminal background or has had documented negative engagements with police, then that's those would be causes for a determination of unsuitability.
Would prior involvement in organizations that have perhaps protested use of force or engaged in criticism of police be an unsuitable factor?
No, not in and of itself. Obviously we support the right for people to demonstrate, and so that certainly would not be a disqualifier.
Is there any other factor that's considered unsuitable?
Nothing that I'm aware of at this point. Obviously, we're not vetting them to see if they're suitable to be Denver police officers. We're vetting them to see if they are appropriate for for a community board.
Now, let's switch it a little bit and look at suitability then.
Right.
Suitability different from unsuitability. What is taken into account for suitability?
Well, I think that what's taken into account is why do you want to participate? Are you a Denver resident, or do you what is your sort of connection, I guess, to the city? Like, why is this important to you? So I would imagine that if you did significant business in the city, lived in the city, where you have significant interest in the operations of the city, those are things that would be that would go towards suitability.
Okay. How about prior experience with police or like I was a military police officer, which I wasn't, but would those help you in perhaps being appointed?
I wouldn't say that. Like, it's certainly not a disqualifier, but we're not searching for people that have prior police experience or military experience.
Okay, thank you. Those are my questions.
Stefan, go ahead.
Yeah, Chief, I think my understanding is it's obviously has been very, very difficult to fill community spots on that board.
Right.
And correct me if I'm wrong, did you think that the primary reason was the level of time commitment? I know, to address certain cases, I don't know if there was a compensation issue as well, but can you address that, please?
Yeah, thank you for the question. So, that is one of the things that we have heard, because we've actually engaged other people who have sort of inquired about the opportunity. And one of the things that they have indicated as to reasons why they are not interested is the time commitment. Obviously it takes, we don't do use of force boards all the time, thankfully. But when we do, the cases, the complexity of the cases, the volume of information that is necessary to review, takes a significant amount of time. And we have had questions about compensation, and I think at this point we are reluctant to compensate people for a volunteer position. That seems to kind of take away the voluntariness of it, and maybe even call into question someone's desire to perform that particular community service. And so at this point we are kind of holding fast on it being a volunteer position, but just again expanding our net in terms of trying to identify people that are interested.
Okay, thanks. I mean, I just my own personal view on that, I don't know if it would make a difference or not, but given the level of time commitment, I would think just a modest amount of compensation, like our board, for example, is very, very modest, but at least it's some recognition of the time that's spent. I don't know if that would make a difference or not. You'd have to try it and find out. I know Julia really, pushed hard to get a modest level of compensation for people serving on this board because of the level of time commitment. So I think it'd be something worth considering.
Sure. Well, it's not off the table, certainly. So
Yeah. Okay. Thank you.
Go ahead. Go ahead, Chief, with the next question.
So I think we're at number 3, which says DPD policy, which is OMS 503.01 parent 5 parent C, allows for complainants to be dismissed if a lawsuit has been filed. How often has the DPD relied on that policy to close misconduct complaints without conducting a formal investigation? So let me first just kind of read what 503.01 5C reads, which is judicial or administrative review. The complainant could reasonably be expected to use or is using another remedy or channel for the grievance stated in the complaint. Complaints that are subject to judicial, administrative, or other review, which will implicitly or explicitly require finding or ruling on the conduct that is the subject of the complaint, may be dismissed. A complaint should be dismissed on this basis only if the alternative channel is reasonably accessible to the complainant and can provide an adequate remedy. And so, as stated in the policy, the complainant, by filing a notice of complaint, is already utilizing another remedy to resolve their grievance. However, we do not arbitrarily dismiss or close claims because a lawsuit has been filed. We regularly complete investigations on cases that also have a lawsuit attached to them. Every notice of claim is thoroughly reviewed, and the decision to complete a formal investigation is determined by looking at several factors such as, is there a policy violation against a specific officer? Is a claim regarding a matter of law or fact that is better addressed through a judicial remedy or civil liability? And how long has it been since the incident occurred? Now, I think connected to this is the fact that the Executive Director of Safety's office created the notice of claim process in 2012 in concert with the Office of the Independent Monitor and Civil Liability. It was determined that these claims are not and were not meant to constitute a complaint. Claim notifications sent to the OIM and Civil Liability were sent for their review to determine if additional investigation of the claim should occur. They're forwarded us to from OIM for that determination, and based on our practices outlined, that is what we do, and the city attorney's office does agree that we are addressing these claims that are forwarded to us properly. Now, just to kind of talk specifically about what we have done recently, in the last year and a half, 39 notices of claim have been received. 15 of them have resulted in or already had internal affairs cases open. 7 were related to property damage and were referred to civil liability. 1 was an officer involved shooting that was addressed through the normal process. 1 was a death in jail days after contact with officers after ingesting fentanyl. 2 were illegal search claims where there was no policy violation found. 2 were property damage complaints that were forwarded to civil liability. 2 were persons with mental health issues that were routed to our CIRU as no policy violations were identified. 3 were deemed trivial with no policy violations observed. 5 were claims of improper arrest or citation with no identified policy violation. And then 1 was a claim that officers searched the home after a home invasion and pointed their weapon at a person who was hiding in the closet. That person was later identified as the victim. And so it was determined in that case that there was no policy violation. So other questions or comments on question 3?
Yeah, so there was a wasp flying around my office, so I got distracted for a second. But what you said was if a person is suing, they must also submit a claim or a complaint.
What I'm saying is that we get notices of complaint. We've gotten 39 in the last year and a half, and typically what happens is they are sent to us by OIM, or they could be sent to us by civil liabilities. And our process, which has been in existence since 2012, is that we review those notices of complaint. About half the time we identify that a complaint is already generated, which will continue. If a complaint is not already in process, we will look at the claim, identify whether or not there appears to be any policy violation, or whether this is really just something that is best determined by the court, like an illegal improper arrest or citation or property damage, which usually occurs when we are engaged in a lawful police action. And so you don't have to file a notice of claim in order for a lawsuit or things that are subject to a lawsuit, or I guess where there's a threat of a lawsuit. You don't have to file a notice of claim in order for us to investigate that. If those claim, if an incident is brought to our attention, we're going to review it for policy violations. And often our first notification of some report of misconduct or behavior that didn't meet the subject's expectations. sometimes our first notification is through that notice of claim. Yeah, we take that notice of claim, we look at what we have available to us to determine, is this a situation where we should investigate claims of misconduct or not, because we've not identified any misconduct.
Okay, so summarizing what you said, the department receives a complaint, or Department of Law for the city, who would sort of be the recipient of that legal filing, or the lawsuit in this case?
So I think that most of our civil liabilities bureau receives those notices of complaint.
Okay,
And so they then route them to internal affairs. There have been occasions where OIM has sent us notices of claim. And I think in many of those instances, we already received it, have already reviewed it, and have already determined to open a case or identify that there's not a need to open a case.
okay, so there's like some process routing from civil liabilities to your internal affairs group,
Cool.
who then start to vet it in a standard way.
Cool. And that-
Okay.
and-
And so the language says, like, we could dismiss it if it's a lawsuit. And what you're saying is that doesn't happen very often.
Right, yeah, just because a lawsuit has been filed doesn't mean that we're not going to investigate a claim of misconduct.
Okay. Okay, go ahead, Stefan.
So, Chief, if I'm understanding this correctly, I think what you're saying is if you get a notice of claim, I'm distinguishing that from a complaint.
Yeah.
You know, and you get a notice of claim of a lawsuit that is going to be filed or has been filed. You, in essence, treat that as a complaint that would be made to internal affairs for an allegation of misconduct, and you would investigate it like you would if there was just a complaint against a uniformed personnel, unless you determine that the matter is better handled through the judicial process. Is that an accurate summary?
Somewhat. I would maybe use different language, like we don't necessarily investigate it, but we will review the facts as submitted to us, maybe even review other information that we would have to determine whether or not it would be appropriate to open an internal affairs case. And so just like, so I guess what we would do is a standard intake, just like we would do a standard intake of any other complaint that would be routed to us from.
Yeah.
We would do an intake, and if it was determined that there is potential for misconduct, then we would conduct an investigation. If it was determined that what they're claiming that we did is not a violation of policy, then we wouldn't open a complaint.
What if somebody concurrently filed there was a notice of claim and an internal affairs complaint, sort of the standard misconduct thing?
Yeah,
Do you treat that any differently?
No, we wouldn't handle it any differently. So, we would review both and determine, is what they're alleging a violation of policy?
Mhm.
And if the answer is yes, if what they're alleging is a violation of policy.
Oh, we're losing sound again, Chief. Losing sound.
Sorry,
Again.
I think I maybe keep sliding away from the
Okay.
from the microphone. But anyway, so let's say, if we get a notice of claim that says that we're suing this officer because this officer assaulted me, then we would be investigating a law violation or inappropriate force. We would be investigating that. But let's say, and so the lawsuit would continue, as would our investigation into that allegation of misconduct. But let's say the facts are, this officer shouldn't have cited me for speeding or shouldn't have arrested me for trespass. And our understanding is that, well, it's actually for a court to decide whether or not you were actually speeding and deserve the ticket, or whether or not you should have been arrested for this incident, which clearly had probable cause. You know, that's where we would not open a internal affairs investigation and allow the court to determine a finding on that particular claim.
Are you saying, giving those two examples, are you saying somebody would have filed a notice of claim based on the fact that they thought they were falsely arrested or cited or something?
It's
That's what you're
happened.
saying?
It has happened.
Really?
Well,
Okay.
people file notices of no claim because they didn't feel like they should have gotten a citation, or they don't feel like they should have gotten.
Really? Okay. I wasn't able to follow. Did you have stats on this? I don't know if you were saying in terms of the number of.
I did, and let me go back. If I can
Yeah,
find.
I wasn't able to follow. Sorry.
Yeah, no, I appreciate it. So, last year and a half, 39 notices of claim have been received. 15 of them already had internal affairs cases opened. 7 were related just to property damage, and so they were referred to civil liability. 1 was an officer-involved shooting that was, investigated through the normal investigative process. 1 was actually a death in jail days after officers, I think engaged in a foot chase. The individual ingested fentanyl, later died in jail days later. 2 were illegal search claims where our review found no policy violations. 2 were property damage. Again, no policy violation found, just property damage that people wanted compensation for. 2 were I don't want to say they were frivolous, but they involved individuals with mental health issues, and those were routed to our unit that handles individuals that have mental health challenges. And then 5 of them, again, involved either the claim of improper arrest or citation.
So that you had the denominator there was a total of 39, and that's over the course of the past year. And then those are all the subsets of the 39.
That is correct. Year and a half.
Okay. Okay. All right. Thank you.
You're welcome. Maybe a different lens on that question, but I think I'd be interested in understanding the stats of when a court case rules against DPD, but the internal affairs or internal discipline processes review and determine there's no violation of policy. Is that data that we could get a hold of?
I'll look into that. So where there's a judgment in court, and how that compares to determinations of misconduct.
Yeah.
Okay.
I think that would be helpful.
Sure.
Awesome. Okay.
One
Go
other
ahead, Karen.
in that regard, is your response any different after a court decides differently or contrarily to what the DPD investigation prompts you to do? For example, if you investigate a situation and decide that there's no harm, so to speak, but a court decides that there was harm, does that affect the decision that you made?
It doesn't. I think it actually would be inappropriate for it to do so.
I can't hear you, sir.
I'm sorry. So I said it doesn't, and I think it would be inappropriate if it did. So so I think our process has identified that there was no misconduct on the part of the officer, or whatever the alleged conduct was, exonerated. And if a jury or a judge makes a different determination, I I don't know that that really changes our analysis, you know, because I think the evaluation is similar but different, you know. So for instance, if an officer uses pepper ball in a certain situation and it doesn't violate our policy, but then a judge or a jury decides that the individuals should be compensated because DPD deployed pepper ball in a certain situation and they had some medical complications because of that deployment. I don't think that changes the fact that we decided that the officers acted within policy. It was just a judge or jury's determination that that those individuals should get an award for that event.
Okay.
I mean, that would, I guess the reverse of that would be, let's say that we find that an officer has violated policy, and then there is a subsequent lawsuit that is filed by that individual against the officer, and the judge or jury finds there is no verdict against the officer and there is no compensation to that individual. We're not going to go back and say, okay, well, I guess we'll change that determination that we made that the officer violated policy. We're not going to change that.
Okay.
Are we ready for number 4?
I think we're ready.
Okay. So number 4 is we've seen a shift in internal affairs cases related to use of force, from using the inappropriate force specification to using the duty to obey department policy specification. This change took place several months over you took over leadership of the department. Can you speak to why the inappropriate force specification is no longer being used? And so really, the use of force specification has undergone numerous, or our policy has undergone numerous revisions and is more inclusive than it was many years ago. And, when analyzing a complaint under R 306, which is inappropriate force, the Conduct Review Office must cite specific policy violations within the operations manual already. And just to kind of give some historical background information, and I think maybe the concern is the conduct category that a sustained violation of R 306 was a category D. Well, if we are, I think, a little bit more specific about which part of the use of force policy that didn't exist when 306 was first enacted, which specific part of that policy is violated if it is a sustained application of force allegation. Those, and we've had 5 of those, and all 5 of those were sustained at a category D, so the same result. Then, when we get to violations of the use of force policy, which actually involve the actual reporting, like so failure to report or doing something inaccurate in a report, then the reporting spec, I think, is more appropriate. So really all we're doing, I think, is being a little bit more specific about the conduct with the specification that we're using. I think we're coming to the same disciplinary conclusion that we would otherwise. And actually, it's our position, I think, to remove 306 altogether because it's duplicative, I believe, and I think it removes the opportunity to if you were to do a search on use of force violations, I think it would hamper your ability to be specific and identify trends or things like that, if we were to want to see how many people use a level of non-lethal force inappropriately versus how many people were to actually use inappropriate force, we would be unable to do that if we just use 306. But if we use 105.1 and the various parens underneath, I think we could very clearly tell how many people have force violations that are specific to using non-lethal force when not appropriate, or when using force in general when not appropriate.
So I guess a question in my mind is like, does this, seems like any policy violation could be considered a failure to follow departmental orders. And so I guess a concern that I might have is that we would end up with a really generic data set. But what you're saying is that's the opposite. And so is that because the taxonomy then breaks down and you've got more information based on use of force?
Yeah. So I mean, so the 102, which is the failure to obey policy, roughly, and then there's reference below that to a specific policy and a specific subset within that policy, and so that's what allows us to be much more specific about what an officer did. Did an officer violate the use of force policy as it relates to reporting? Did an officer violate the use of force policy with respect to using a form of less lethal force that didn't have the commensurate actions by the subject, or was this just an application of inappropriate force in general? So I think it allows us to be much more specific, provide much more specific detail in our reporting. And
is that detail a field? Like I could download a data set that then says, here are all the actual uses, inappropriate use of force, or it's like in the text. And so then one would need to do sort of more detailed analysis to be able to suss out actually what the violation is.
There are subsets in 105 that relate to non-lethal force, lethal force, force in general, reporting, and so we would be able to be very specific about what violations of our use of force policy had occurred.
And like in IA Pro, it would be like the first field is like failure to follow departmental orders, and then the next field would say accidental discharge or failure, inappropriate force or something like that, or it's actually in the text of the write-up.
Right. And so
wait, sorry, those are two different things. It's a field that's searchable, or it's in the text of the write-up.
That's searchable, and so that's how I've been able to get some very detailed information. So prior to the change, 5 cases resulted in a sustained finding of R306, and they all resulted in category D violation. And then we've had, since the change, we've had 8 sustained cases of OMS 105, which is the use of force section. 5 were due to actual inappropriate force that again resulted in the category D determination. So this is not an effort to try to lower the penalty. Penalties are the same. And then we're able to be even more specific, identifying that of those 8 cases, 2 of them involved an officer's failure to report the use of force. And then 1 of them involved an officer's failure to complete the show of force report, which is, when you point your weapon at someone. And so we're actually able to be very specific on which sections of the use of force policy were violated.
Okay. Was this change reviewed and discussed with the monitor's office before it was made?
Yeah, a number of times there's been quite a few email exchanges between our conduct review office, our internal affairs bureau, and Monitor Castle. And my suspicion, again, I think is I think maybe there's two concerns, both I think legitimate concerns, but one, the concern that this might be an opportunity to pull something out of the appropriate conduct category, which has not happened. And then the other, maybe just some data, that would, like if you were comparing data, say in 2020 of RR 306, and then you compared that to RR 306 in 2024, you would go from whatever the number was in 2024, which would suggest a reduction in force complaints or force violations, which is not correct. And I think we can clarify, that we are still tracking our force complaints, our sustained force violations, just tracking it in, I think, a more precise manner. I don't think that those folks that sat in those rooms for all of that time to redo our use of force policy and be much very specific about it, I don't think that they did that in vain. So I think it's more appropriate to use that that policy, that specific policy that I think everyone worked very hard to create. I think I think it would be prudent for us to use that in reviewing all of our force related complaints.
Monitor Castle, is there any any comment you want to make and sort of concerns about this change?
There has not been, as far as I know, a formal policy change. That is what we would weigh in on. I understand.
This seems like a procedural change, right? So have you had conversations with the department about sort of the impacts, and are you comfortable with this change?
We've had some discussions, but nothing formal.
Okay. Perhaps this is worth bringing back up in a future meeting. I have a couple of other questions that I want to get to, and I know we're sort of running short on time. So Daniel, let's just put a bookmark in this, and if board members are okay, we can come back to this, because it does seem, matters of public concern relate to transparency, particularly in this time when, data is being deleted and there's, sort of like concerns that people can get access to the truth. And so creating sort of text that's searchable is really different than being able to sort based on fields and make sure that we haven't genericized information. What I hear you saying is that we haven't, but I think I'd like at least a little bit more clarity there. Two questions, if other board members are okay moving to a different topic, can you just give a thumbs up? Because I want to ask. The mayor had to come and testify in front of Congress with a bunch of other mayors. And, a lot of that was about the relationship of the city to newcomers. Have you received any new directives or indications of policy changes as a result of that testimony?
No, absolutely not.
Okay, thanks. The second question that I have is, I've been collaborating with our colleagues over at Together Colorado, and I understand that in December you presented a presentation on education-based discipline to them, sort of at the end of a meeting. And from what I understand in that presentation, the proposal was to change about 60% of the disciplinary actions that would be taken by the department and shift them to sort of more of a educational based approach. Have you gone back to Together Colorado with more information on that? Do you plan on doing that, or have you shared that information with other community organizations? And do you have plans to do that?
So at this point, I had shared that information with 3 different groups, and the presentation was actually extensive. But I'm actually at this point waiting on feedback from the Office of the Independent Monitor, and I think it would be important to include that before doing any additional stakeholdering.
Okay. I think we'd agree as a board that significant changes to the disciplinary process should be thoroughly vetted with community. So I encourage you to do that. Okay. Do board members have other questions or topics that we'd like to cover with the chief?
I do not.
No. Okay, thank you, Chief. Is there anything else that you would like to discuss?
I mean, I can do
Go ahead, Rufina. Sorry, I see you just raised your hand.
No, I did just want to express our sympathies for the force regarding the officer who committed suicide. And so we want to just express those sympathies.
Thank you very much. And then Julia, I can probably quickly answer 5 and 6 if you have time.
Sorry, we're losing you again.
I said I can answer 5 and 6 fairly quickly if we have time.
Oh, I think we have time if you'd like to go through them.
Yeah, absolutely. So number 5 is, what is the current status of the DPD drone program? And do you have an estimated time for when you might start using drones as first responders? And so patrol-led drones have been ordered for each district. We also have a drone assigned to our tech bureau for special operations, and 2 are assigned to our Metro SWAT team. Those are for interior use when we have a search warrant. We have several certified drone pilots that are online now, and we've identified pilots in each district that we are going through the certification process with. We're also in talks with a vendor to pilot a drone as first responder program, which we hope to be in place by the end of the summer. So we are sort of, crawling, walking, running. And so we hope to have much more extensive use of drones going forward. And then that kind of goes into number 6, which is, there have been a lot of protests in the past 2 months, with the largest likely being on February 5th. Did the DPD use drones to monitor protesters on that day and for any other recent protests? And so the answer to that quickly is yes. We did fly a drone that day and on other large protest days. We do that again to monitor crowd size, to identify directions of travel, because as you know, we go through quite an effort to make sure that we block traffic so that there's no dangers created to the demonstrators or to the motoring public. It also helps us identify whether or not there are any illegal activities going on, like window breaking or assaults or anything like that. Helps us identify that behavior and then track the suspects that are responsible for that. And so that is how we have used the drones during those operations. And usually those are drones that belong to the fire department, because they are able to stay in the air, though their drones are able to stay in the air longer than ours are. So we're using fire department drones with fire department personnel with us as we're operating and monitoring what the drone is viewing. Thanks.
Stefan, go ahead.
Chief, with respect to those demonstrations, and I imagine there will be more in the future, were there any significant incidents in your mind with respect to the demonstrations that have occurred to date?
Generally, no. So most of them go off without any incident at all. No arrest, no significant engagements at all. I do believe there was one 2 weeks ago, I believe, where there were a couple of arrests for assault and destruction of property, 2 or 3 arrests at most. We waited until those individuals separated from the crowd to limit the attention to those incidents. I think it was during the March last week, the 5th, we did have the back window of one of the police units that was helping to block traffic. We did have a rear window that was shattered with what I don't know. We don't know if it was a slingshot or a rock or something like that. We did have a window that was shattered, but outside of that, no significant engagement at all.
And the fire department drones are able to fly longer because they're bigger drones, different models than you're using, or they have a different policy on flight.
No, it's mechanical issue, so they're larger.
Sorry, I'm losing you again.
Yeah, you're correct. They just have larger drones with greater flight capacity. Batteries last longer.
Thanks. Other board member questions? All right, Chief Thomas, thanks for spending some time with us today. It sounds like we've got at least a couple of items to follow up with you on, and especially that data that we asked for, I think would be helpful if you could follow back up with us. That would be incredible. So appreciate your time today. And again, sorry about the loss for the department. I know that can be really challenging for a whole force. So
Thank you.
okay, shifting over to the, oh, go ahead, Stefan.
No, thank you, Chief.
You're saying bye.
No.
Thanks. Okay, thank you. Monterey Castle, is there any anything you want to cover in our public meeting here?
Yes, please.
Okay. I'll turn it over to you then.
I apologize. Executive session.
Okay. You have
All right.
matters of ongoing deliberative privilege that you'd like to discuss in an executive session?
Yes, please.
Okay, great. Is there anything that the board would like to discuss in the public realm? If not, I may have a motion to adjourn to executive session.
So moved.
All in favor, aye?
Aye.
Hi.
Any opposed? Okay, well, this concludes the public meeting of the Citizen Oversight Board, and we'll transition to executive session. See you all over there. Thanks.